Premier and Minister of Finance, Dr. the Honorable D. Orlando Smith, OBE, and Mrs. Smith, OBE, Speaker of the House of Assembly, the Honorable Ingrid A. Moses Scatliff, Deputy Premier and Minister for Natural Resources and Labor, Dr. the Honorable Kettrick Pickering, members of the Cabinet, other members of the House of Assembly, the Honorable Attorney General, Mr. Baba Aziz, His Lordship Justice Barry Leon, Deputy Speaker of the House of Assembly, the Honorable Dolores Christopher, other members of the government, distinguished guests, colleagues, ladies and gentlemen. It gives me great pleasure to welcome you all this evening to this, the second biennial Dr. J.S. Archibald QC Memorial Lecture. It gives me even greater pleasure and a particular thrill to acknowledge the presence of Mrs. Inez Archibald, widow of the late Dr. Archibald QC. I should also acknowledge the presence of his daughter, Pat, who is also present this evening. And Mrs. Archibald, you will forgive me if I get a tad personal in public and to say how happy and absolutely thrilled I am to see you this evening, once again in the pink of good health and a picture of characteristic elegance, grace, and poise. What a joy. The institution of the Dr. J.S. Archibald QC Memorial Lecture Series on arbitration followed on the heels of the successful undertaking by the focus group on arbitration to develop a modern arbitration legislative framework for arbitration in the British Virgin Islands. The work of the focus group was ably guided by none other than Dr. J.S. Archibald QC, Archie, as he was fondly called, in his role as chairman, a role to which he brought the passion and characteristic vigor and commitment which epitomized his every endeavor, throwing himself headfirst into it all. Archie was not only a giant at the BVI Bar, but his prowess was also well known and is well documented in the wider Eastern Caribbean. Here to tell us more about Archie's pivotal contribution to what ultimately became this wonderful facility and which has led to our celebration of his contribution to that, is the President of the BVI Bar Association, Ms. Jacqueline Daley. May I ask you to welcome Jackie to the podium.
Good evening, ladies and gentlemen. I hope you will allow me to adopt the protocol previously established, but also to say a heartfelt welcome to Mrs. Archibald and the other members of the Archibald family who are specially invited guests this evening. It's a pleasure to see all of you for this momentous event. Today we have assembled here for the second biannual Dr. J.S. Archibald QC Memorial Lecture. The reason I'm here actually is because in addition to the International Arbitration Center putting together this lecture, the decision was made that the BVI Bar Association would also participate this year. And the history behind that is that 2 years ago, these two organizations both hosted separate lectures honoring Dr. Archibald. We did so clearly without communicating with each other. And in such a small place as the BVI, once we realized what we had done, we thought that this year, rather than doing things separately, we would come together and give a big, strong presence to say thanks for everything that Dr. Archibald has done for the legal fraternity and for the arbitration fraternity in the BVI. There are some things I think that unequivocally go well together. These pairings are seamless, effortless, and seldom challenged. And in the everyday context, they include things like peanut butter and jelly, or chocolate with just about anything. And for Caribbean people in the audience, or potentially for those of you who have gathered here and have come from faraway lands, but who maybe have immersed yourselves in Caribbean culture over the last few days, one of the other things that we here in the Caribbean say go well together is the perfect marriage of the delicacy of rum and coconut water. And so it is with that in mind that we have created, I think, what I call a perfect pairing, and that is the pairing of the International Arbitration Center with the BVI Bar Association to bring you this memorial lecture to celebrate the life and legacy of Dr. J.S. Archibald QC. The decision of the BVI Bar Association to sponsor this lecture was, needless to say, a very easy one. And these two organizations have something very much in common, and that is the gift of the life of Dr. Archibald. Both of these organizations were formed actually through the hard work and dedication of Dr. J.S. Archibald QC. Over 40 years ago, Dr. Archibald had the insight to stand as one of 8 persons who were founding members of the BVI Bar Association. And I think he may have liked the number 8 because, interestingly, he would go on to serve an 8-year term as the BVI Bar Association's president from 1986 to 1994. This has been, and based on my experience as president, in all likelihood will continue to be, the longest term of any president of the BVI Bar Association. You will hear from Sidney Bennett QC, who will give you a biography about Dr. Archibald, that he was an active and vocal member of the BVI Bar Association. During his professional life, Dr. Archibald was recognized as a masterful advocate in the courtroom and a fearless defender of justice. But very importantly, he understood and appreciated that justice should not be confined only to the courtroom, but should instead be accessible via various forums and fora. That ability to recognize the importance of allowing for different avenues for dispute resolution would make him the obvious choice to act as chair for the International Arbitration Focus Group that is established by the BVI Financial Services Commission in 2011. The work of that focus group under Dr. Archibald's meticulous leadership would result in the enactment of the Arbitration Act and the creation of the BVI International Arbitration Center, which is where we all sit today. Dr. Archibald was an educator. He may not, to the best of my knowledge, have taught in a classroom, but many distinguished jurists will regale you with anecdotes of lessons learned from him in his correspondence, in his chambers, if you had the opportunity to visit him there, in the courtroom, but also in circumstances and environments just like this one. He gave many lectures and always sought to educate and uplift both members of the general public and members of the legal profession. In fact, I understand that the focus group intended to have an annual lecture, and that series was intended to educate the public, as we hope to do here, on the benefits of arbitration. And Dr. Archibald was slated to be the very first speaker in that lecture series. Sadly, he was taken from us before we had an opportunity to hear from him. But as we gather here to commemorate Dr. Archibald QC in a way that I believe he would have loved, this lecture series allows for the dissemination of information and the promotion of alternate dispute resolution through arbitration, and will be followed, courtesy of the Bar Association, with the coming together of colleagues and friends over canapes, maybe even a little chocolate. As I said, some things unequivocally go well together. I hope that you enjoy this evening's lecture. We'll be listening to mood music on arbitration, and I look forward to seeing many of you in 2 years' time to celebrate yet again the 80-year lifespan of Dr. J.S. Archibald QC, a stalwart and visionary of the legal profession.
Thank you, Jackie. I should like to, at this juncture, also formally acknowledge the presence of the other members of Dr. Archibald's family who are also present with us this evening, seated in the front row. Jackie spoke a little bit about Archie's professional career. And I believe no one is greater qualified to speak about Archie in that respect than his colleague of the better part of 2 decades and his partner for the majority of those years, none other than Sidney Bennett, Queen's Counsel. And so at this juncture, would you help me to welcome Sidney to the podium to say a little bit about this giant of a man who was his partner for many years.
Thank you, Mr. Chairman. It was 25 years. I gratefully adopt the protocol which was established by the chairman, and not only that, but I heartily endorse his sentiments. Joseph Samuel Archibald, Queen's Counsel, was born in St. Kitts Nevis in the West Indies in January 27, 1934. A graduate of the St. Kitts Nevis Grammar School in St. Kitts. On 12 July 1960, he was admitted to the bar as a barrister of the Honorable Society of Lincoln's Inn. And he served his first few years in practice in the offices of High Court Registrar, Magistrate, Senior Crown Counsel, and President of the Civil Service Association, Director of Public Prosecutions in St. Kitts Nevis, Anguilla. Dr. Archibald moved from St. Kitts to the British Virgin Islands to practice law, and he settled on Tortola, where he served as Crown Attorney. That would be now styled the Attorney General. Among other posts, he served as Chairman of the Legislative Council Committee for Constitutional Reform in the British Virgin Islands between 1964 and 65. In 1968, he founded J.S. Archibald & Co. and began a storied career as a private practitioner. In this capacity, he appeared before the courts of the Eastern Caribbean at all levels, up to the Judicial Committee of the Privy Council in England. A legendary practitioner before the criminal bar, Dr. Archibald achieved notable success in civil litigation, property law, banking and insolvency practice. He was inexhaustible in his research and in his approach to the solution of legal problems, meticulous in preparation of his arguments, and he maintained a large and constantly expanding legal library. He was elevated to the rank of Queen's Counsel in 1980. Subsequently, he appeared in an impressive number of notable and not a few landmark cases. I've heard it said that he was a teacher, and if you look at the people that graduated from his school, the present Chief Justice, the head of the CCJ, which is the Chief Judge in the Caribbean, many, I see Queen's Counsel Jerry Ferrara, and many others who have come out of his school. Dr. Archibald served as a judge of the High Court and of the Court of Appeal of the Eastern Caribbean Supreme Court on numerous occasions, often for extended periods. In 1978, he served as an acting judge of the Supreme Court of the West Indies Associated States. Assigned to Dominica, in 1998, he served over 2 months as a judge of the High Court in St. Lucia. Among his many stints as an acting Chief Justice of the Eastern Caribbean, as an acting Justice of Appeal of the Eastern Caribbean Court, he sat for the period May to October in 2001, and between June to July 2004. Now, when you look at his career in perspective, his career as a lawyer spans 54 years, 33 of which were at the inner bar. It is not possible to do true justice to the fullness of his contributions within the limited time available. But most noteworthy, I would like to stress Dr. Archibald's deep and abiding belief in the rule of law and his unstinting efforts for the development of legal institutions and processes, and for the advancement of the profession to which he devoted the greater part of his life. Dr. Archibald was one of the first presidents of the BVI Bar Association, serving from 1986 to 1994, a period which is longer than any other president. He was the founder and founding president of the Organization of Eastern Caribbean States, the OECS Bar Association, from 1991 to 1996. In that capacity, he oversaw the ethical standards and rules guiding practitioners. As chairman of the Civil Justice Task Force, he extensively contributed to the creation and implementation of the Civil Procedure Rules 2000, which are the civil procedure rules currently in effect throughout the jurisdiction of the OECS. In 1988 to 1996, he served as chairman of a committee of attorneys general of the OECS, appointed by the heads of government for the creation of a single judicial and legal service for the sub-region. In 1989, he served as member of a 3-man panel of international lawyers appointed to evaluate the justice systems of the OECS states and Barbados under the US UWI Justice Improvement Project. Dr. Archibald had for years strongly advocated the establishment of a BVI commercial court with high court jurisdiction. And in 2006, he was appointed chairman of the BVI Bar Committee to explore the possibility of establishing such a court. The court was established in 2009, May 2009. Again, he advocated strongly for the inclusion of a Bill of Rights in the BVI Constitution. That too has been done. Dr. Archibald's exertions extended to advocating and working tirelessly for the development of the Caribbean Court of Justice. In July 26, 1996, he delivered the inaugural Sir Archibald Ned Memorial Lecture in Grenada, West Indies, on the essentials of a West Indies Supreme Court. That is a court to replace the Judicial Committee of the Privy Council as the final appellate court for Caribbean Commonwealth states and territories. He advocated tirelessly on this subject in several lectures. That court was inaugurated on 16 May 2005 in Port of Spain, Trinidad. 24 May 2006, Dr. Archibald was appointed to be a member of the Regional Judicial and Legal Services Commission. That is a body which appoints judges and recommends the appointment of the judges and the Chief Justice of the Caribbean Court of Justice. And he was appointed for a second term to that body in 2010. It is fitting that as we speak about his contributions to arbitration, that we note the outstanding contributions that he made. He was a member of the Constitutional and International Arbitration Committee of the Washington-based World Association of Lawyers, which is now known as the World Jurists Association, from 1976 until the end of his life. He was also a member of the Arbitration Project Advisory Committee of the Caribbean Law Institute from 1989, and a member of the London Court of International Arbitrators from 2001 until his passing. In September 1991, Dr. Archibald QC presided as an umpire in arbitration proceedings in land acquisition dispute between the German citizen and the government of the Commonwealth of Dominica. In August 2011, Dr. Archibald was appointed to head a focus group of 7 experts of various professional backgrounds, the International Arbitration Focus Group. This group was tasked with reviewing existing arbitration regime in the territory with a view to establishing the BVI as a center for international arbitration. The efforts of this committee resulted in the passing of the Arbitration Act 2013. Dr. Archibald was particularly concerned with having the New York Convention on the Recognition of Foreign Arbitral Awards extended to the Virgin Islands. This was accomplished on 25 May 2014, shortly after his passing. He presided over the drafting of the arbitration rules, and indeed, at the time of his passing in April 3, 2013, he had scheduled a meeting for the next week for the finalization and discussion and finalization of those rules. Short in stature, Dr. Archibald was in many ways larger than life. He was a raconteur and teller of tall tales and many war stories. His sense of humor delighted and entertained his large circle of friends. An introvert he was not. He was sensitive to the perspective and concerns of persons whom he was called upon to help. He was profoundly charitable in inclination, and he did many acts of kindness quietly and without fanfare. The University of the West Indies has awarded the Joseph S. Archibald QC International Law Prize to final year LLB students since 1990. In October 2005, the University of the West Indies bestowed upon him the honorary degree of Doctor of Laws. Dr. Archibald's name was inscribed on the Rule of Law monument among 18 names of outstanding members of the World Jurists Association and donors of the monument, which stands at St. Margrethen in Austria. And that St. Margrethen is a town on the border of Austria and Hungary. And although everybody knows that about the falling of the Berlin Wall, the actual lifting of the Iron Curtain started at that town. And that is where, because that is the first part of the Iron Curtain, which was literally a wall that was taken down. That happened in 1989. Dr. Archibald departed this life on 3 April 2014 at his home in McNamara in Road Town. He is survived by his wife of 48 years, V. Ines Archibald, the former deputy governor of this territory. There are 3 daughters and 5 grandchildren. His outstanding contributions to our community, to the legal profession, to the Eastern Caribbean Supreme Court, and to the legal, social, and educational institutions in this East Caribbean sub-region must surely stand as an inspiration for future generations. Thank you.
Thank you, Sydney. It's truly heartwarming to see such a wonderful turnout in tribute to this giant of a man, bobbing and weaving wherever he is, as he liked to say. How are things, Archie? Bobbing and weaving as usual. And I'm sure wherever he is now, he's bobbing and weaving and very pleased. Our guest lecturer, John Beechey, CBE, is best known to us locally as the chairman of the board of the BVI International Arbitration Center. But like a cat with 9 lives, he has known many different incarnations over a long and illustrious career. Were I to attempt to do justice to this career, we would never get to his lecture, which is the purpose of our gathering here this evening. So I will simply give you the highlights. John is among the best-known arbitrators in the world. He has served as chairman, party-appointed arbitrator, or sole arbitrator on international arbitral tribunals in both ad hoc and institutional arbitrations under the rules of, among others, the European Development Fund, the International Chamber of Commerce, the International Center for Dispute Resolution, International Center for the Settlement of Investment Disputes, the London Court of International Arbitration, the Permanent Court of Arbitration, the Singapore International Arbitration Center, and the Stockholm Chamber. He's a past president of the International Court of Arbitration of the ICC and has served on the executive board of the AAA New York as a vice president and member of the board of the LCA. Before his retirement from private practice in the City of London, he was the founding partner and head of the highly regarded international arbitration group Clifford Turner, subsequently Clifford Chance LLP. He's the president of the ICC UK's Committee for Arbitration and ADR and a member of the governing body of the ICC UK. John has also served on the advisory panel of Woodsford's Litigation Funding, a member of the Council of the Australian Centre for International Commercial Arbitration, and a member of the Council of Arbitration of the Mumbai Centre for International Arbitration. He was an observer for the AAA and more recently for the ICC at the UNCITRAL Working Group. He's contributed to the revision of the UNCITRAL Model Law and the UNCITRAL Rules of Arbitration. He's an occasional lecturer at the Universities of Columbia in New York, Oxford, Milan, Munich, and Vienna, and at the Max Planck Institute in Luxembourg. He is in very great demand as a panelist at international arbitration conferences and as an arbitrator at the Willem C. Vis Moot. Topping all of that, in June 2016, John was appointed CBE, Commander of the Order of the British Empire, in the Queen's Birthday Honours List for services to international arbitration. Shall I go on? I think at this juncture I will simply pause and ask you to help me in welcoming to the podium our guest lecturer, John Beechey, CBE.
Good evening, ladies and gentlemen. I'm wondering how many of those 9 lives I have left. Perhaps at the end of this it'll be at least 1 less. May I begin by, as I understand the custom to be, adopting the protocol established by the chairman, and to offer a particular thank you for having me to this centre, to the Premier for all that he has done to ensure that we are here at all, and to Mrs. Archibald for being prepared to endure another lecture. I'm delighted to see her and to have met her this afternoon just ahead of these remarks to you now. Some 2 years ago, installed in the ICC's new premises in Paris, where I was completing my term of office as President of the ICC's International Court of Arbitration, I read the coverage in GAR, as one does, of a lecture delivered by my friend Peter Goldsmith, in which he'd thrown down something of a gauntlet to New York, London, and Paris. He posed the question whether a new arbitration centre, in the BVI of all places, could not only challenge certain of the world's preeminent arbitration centres, but actually, as he put it, knock them off their perch. Having made a mental note to tease Peter about his provocation, and to ask whether the BVI, of which I had only the haziest of impressions, was somewhere to be visited, and whether Road Town, like an urban equivalent of Rafa Nadal's serving arm, was by reason of its 800 and something thousand corporate inhabitants somehow physically out of kilter with the rest of the BVI, I thought little more about it. Until out of the blue some weeks later, a call came from one Dawn Smith. Now, for those of you who have yet to experience this phenomenon, beware. She's honed the art of the sales pitch to perfection. And once hooked, it's a little late to reflect as Dorothy Parker once did when asked what might be inscribed on her tombstone. Wherever she went, including here, it was against her better judgment. The result of that call is that within the space of the last 18 months, I've come to know the BVI rather well in my capacity as chairman of the board of the BVI IAC. And today I find myself following Peter Goldsmith to the podium to deliver this second Dr. J.S. Archibald QC Memorial Lecture. It's a privilege to do so, because without the energy, the vision, and the commitment of Joseph Archibald, Peter Goldsmith's question would simply not have arisen. Through Dr. Archibald's long and distinguished career run a number of threads, among them a profound Methodist faith, a commitment to human rights, and a determination to bring about judicial and court reform here in the BVI and in the Eastern Caribbean. When diligence and utter integrity are complemented by the long experience of a practitioner with a truly international perspective, the insights gained from holding a number of high political and public and judicial offices, drive and determination, any cause has a formidable advocate. It's the good fortune of the BVI that such a man should have been available for appointment to lead the focus group established by the BVI Financial Services Group in 2011. The work of that group was seminal to the introduction and subsequent enactment of the 2013 Arbitration Act and the extension to the BVI of the New York Convention in the following year. The BVI may now fairly claim that it offers to users a modern arbitral legislative framework supported by a well-regarded commercial court. Arbitration awards rendered here are truly international currency. Now, these are achievements which in themselves are impressive testament to the work of the focus group. But its terms of reference went further. Its remit was to consider the steps necessary to see the BVI on its way to become a recognized centre for international arbitration, which Dr. Archibald foresaw as operating in 2 languages, English and Spanish. When Peter Goldsmith delivered the inaugural Archibald lecture, the BVI International Arbitration Centre was still very much a concept. Barely 2 years on, the centre is a reality. It has promulgated rules which are anchored in modern best practice, and it has published a first list of arbitrators, the compilation of which has been based on principles of cultural and gender diversity. Dr. Archibald's criterion of 2 languages is well and truly met. In fact, the Centre can now offer to users the services of a world-class multilingual panel of arbitrators, and it's in a position to administer and host arbitrations conducted in many of the world's principal languages, certainly all of those widely used in the Caribbean and Latin America. The most obvious demonstration of serious intent is this building. The venue for Peter Goldsmith's lecture was Maria's by the Sea. Thanks to the support and confidence of the BVI authorities, and to some, if I may say so, inspired leadership on the part of the CEO of the Centre, Francois Lassalle, and the sheer hard work of the team of contractors, whom he's encouraged and cajoled in equal measure to complete the works in very short order, we meet here in the premises of the Centre. Before the layout and the finishes were signed off, Francois had visited some of the other leading arbitration centres in Europe, North America, and Asia. It's fair to say that he'd done his homework, and he learned a lot. The result is that this centre has gone short on features such as expensive shelving, which lawyers rarely use because it's never in the right place, and fixed panelling, which precludes any flexibility in the use of the space. And it's gone long on such things as the quaintly named modesty boards on the front of tables, on copious numbers of PowerPoints and communal space for parties and arbitrators. Francois, with the full support of the BVI IAC board, has also been obsessive, and I mean obsessive, about the installation of first-class soundproofing and modern IT. And ladies and gentlemen, on the basis of my own experience of established purpose-built arbitration centres in the likes of London, Paris, Hong Kong, New York, Singapore, Stockholm, Toronto, and Washington, DC, and don't even go looking for one in Miami or Geneva, I can safely say that what you see here does indeed knock many of them off their perch. This is, on any view, a world-class facility, of which the BVI may be justifiably proud. The BVI has then the law, the rules, and the premises. But will there be the work to make this place, to adopt the phrase coined by my friend Nicola Landi, the epicenter for arbitration in the Caribbean? The candid answer is that it takes a while for any new kid on this particular block to make its presence felt. There is no doubt whatever that we can fill this space with court hearings and conferences such as this, but the aim is to bring in arbitrations. And over time, I have every confidence that it will. It's fair to say that the Centre has already received a number of inquiries, which will likely result in BVI IAC clauses being written into contracts. There's been a number of attempts, too, to institute proceedings under the administration of the Centre, but they've foundered, notwithstanding some quite ingenious proposals as to how the terms of existing arbitration agreements might be read to trigger the jurisdiction of the Centre. That is inevitable, in that the Centre was not in existence when contracts which are giving rise to disputes now were negotiated, so the agreement of the parties to any subsequent change in the disputes resolution regime is required. But conferences such as this, which bring to the BVI arbitration practitioners and potential users of the Centre's services from around the world, and which showcase the Centre, are a powerful way of getting across the message that the place is real, and that it is not only up and running, but very much open for business. For the time being, at least, access to the BVI will remain an issue. The need for many to make one flight change has not deterred parties from going to Geneva. 2 flight changes, however, are a disincentive. That will change with the implementation and eventual completion of an airport expansion project. But in the meantime, the inauguration of a jet link to Miami is an important transitional step, and a similar link, I would suggest, to Panama would open up to the BVI one of the principal arbitration hubs in Latin America, through which a great deal of business would flow. And in the meantime, the Centre's management is proactive in arranging transfers from major regional airports into the BVI. It's important to emphasize, too, and to acknowledge that government is acting to ease immigration and related formalities, which would otherwise impact the ability of party representatives, witnesses, experts, counsel, tribunal members, and critical support personnel, such as the transcript writers who have been here today recording the mock arbitration proceedings, and interpreters, freely to enter and to conduct their arbitration business in the BVI. The result is that parties and their counsel who are looking for a stable, arbitration-friendly, common law-based jurisdiction in this hemisphere as a possible alternative to the United States, whether for reasons of neutrality, given the identity of the parties, or because of a concern that restrictions on access may become a real issue there, now have a viable alternative. There is quite literally nothing like the centre anywhere else in the Caribbean, or the Americas south of Toronto for that matter, and I include in that New York City, where the local centre's premises are modest by comparison. Now, some of you will be familiar with the London Centenary principles proposed by the Chartered Institute of Arbitrators as the essential criteria for a successful international arbitration centre. They're to be the subject of a session on Friday, so I won't say too much about them now. But let's run through a very quick checklist, because in the 2 years since Peter Goldsmith spoke, it is instructive to see to what extent the BVI has managed to rank itself by reference to those principles. First, clear and effective modern arbitration law. Yes, it's got that. An independent judiciary familiar with international arbitration. It's got that too. Legal expertise available to deal with international arbitrations here. Yes, and it's growing. And indeed, there is always scope to act as co-counsel, if not as lead counsel, in cases where international cases are turning on matters where BVI law is engaged. Education, this centre is certainly willing and able to provide some. Rights to be represented by advocates of the party's choice, yes. Ease of accessibility in terms of visa requirements and all the rest, yes. Air connections, a work in progress. Functional facilities, I think it's fair to say that that is an understatement for what you see here. Ethical standards, recognized to be high. Enforceability of awards, yes, New York Convention. And immunity for tribunals who are conducting their business in good faith, yes. So that is pretty good in 2 years. So you might conclude that on the basis of what you've heard so far, that the mood music for arbitration, certainly for the prospects of the BVI IAC and for the development of the BVI as a centre of arbitration of choice, is upbeat. And there's good reason to be optimistic. In terms of international commercial arbitration, which is likely to form the substantial majority of the eventual workload of the centre, the outward signs that there is a burgeoning demand for arbitration services. Published caseload numbers for the leading arbitral institutions show a general upward trend year on year, 2016 being no exception. By way of example, the Stockholm Chamber recorded 199 new cases in 2016, its best performance yet. In Singapore, the SAIC saw its caseload increase from 197 in 2014 to 244 cases in 2015 and on up to 307 cases last year. And the ICC enjoyed a significant increase in new cases, up from 791 in 2015 to 996 cases last year. The Hong Kong Centre and the AAA's ICDR also reported increased caseloads, as did CTAC in China. LCIA's 2016 results recorded a slight drop against 2015 to 253 new cases and 50 further cases in which it provided administrative or other support. And it may be that the LCIA has been particularly susceptible to the impact of Russia-related sanctions, since for some years it had been a centre of choice for Russian cases. But there is no reason to doubt that it remains a formidable player. So that is a market into which this centre might expect to tap with some confidence. In addition to work which might be expected to come to the centre by virtue of the fact that it is the first such institution to be operational in a region which has been poorly served in the past, it should seek to capitalise on the fact that this is a jurisdiction which attracts an international client base, not least in the field of financial services. Now they know it's here and here to stay. Local and regional practitioners and legal advisors worldwide whose clients operate through BVI-based corporate vehicles should be encouraged to consider the BVI IAC as a serious and viable forum for the resolution of disputes. And the question of the adoption of a BVI IAC arbitration clause should be a standard item on their contract terms checklists. To a certain degree, the destiny of this centre is in its own hands. It can and it must ensure that it offers a level of service which stands scrutiny against that of the market leaders, that its cost and fee structures are competitive, and that it meets current best practice in terms of both procedural transparency in its administration of its caseload and in ensuring that its tribunal appointments are appropriate to the case. It's equipped to do so, and in its preliminary dealings with case referrals, I will say unequivocally that François Lassalle and the acting registrar, João Vileno Valerio, have put not a foot wrong. But it's not impervious to external pressures, and both those who are responsible for the centre as well as those who support and use its services need to have an appreciation of the challenges with which international commercial arbitration is confronted. Gary Bourne, who visited the centre and gave a seminar here with Professor Brigitte Stern last February, delivered the first Judith S.K. lecture in New York a few months ago in memory of the great judge, jurist, and friend of arbitration that Judith was. He made headlines in the legal press with his warning to the arbitral community that winter is coming. He drew attention to the risk that the political and civil society backlash experienced in the field of investor-state arbitration might spill over into commercial arbitration. It was, he said, time for the arbitration community to defend itself against an army of the undead, which on the basis of wildly wrong perceptions that the current investor-state regime was pro-business and controlled by unelected, unaccountable and self-interested arbitrators in the pockets of investors, demanded more state control over the process. Now, that's pretty dark mood music. And there's no doubt that the current system of investor-state arbitration is under intense and by no means benign scrutiny. The renunciation of the ICSID Convention by 3 South American states, Bolivia, Ecuador, and Venezuela, the debate within the European Union about the effectiveness of intra-EU BITs and the treatment of disputes between EU investors and EU states pursuant to the Energy Charter Treaty, the hostility towards the current system of investor-state arbitration on the part of civil society, powerful NGOs, and the political leadership on both sides of the Atlantic, in the context of first the TPP and latterly the stalled TTIP negotiations, are examples of an extraordinary hostility towards a process which it is no exaggeration to say has been demonized in some quarters. Some of this hostility is doubtless politically motivated, but what it amounts to, whether sincerely held or merely opportunistic, is a very public vote of no confidence in the system. When powerful political voices in the United States refer to arbitration as a system of rigged pseudo-courts, and commentators in Europe call investor-state dispute settlement a toxic mechanism which forced into other trade agreements has allowed big corporations to sue governments before secretive arbitration panels composed of corporate lawyers which bypass domestic courts and override the will of parliaments, it's time to sit up and take notice. In fact, there must be a real concern that it may almost be too late for the arbitral community to change the course of the debate in investor-state arbitration. And to be candid, one of the most worrying aspects of these developments is that there seems to be little, if any, room for proper debate. It's a trite observation that if there is a good argument on the other side, you've got to understand it. But the most depressing feature of the discussion around the proposed investor-state dispute settlement provisions in the context of TTIP was that no one at the Commission or at the European Parliament was even prepared to give the arbitral community a hearing. Their minds were closed. Any solution was weighted in favour of the clamour of an anti-arbitration lobby, long on inflammatory rhetoric and emotion, and very short on fact and substance. As Professor David Caron pointed out in his Kaplan lecture in Hong Kong last December, if trust in the integrity of the process is lost, then the subsequent debate can be deeply emotional and not one easily rebutted by experts in the field. The essential elements of the attack upon investor-state arbitration remain, first, that disputes which affect national interests are in the hands of inherently biased arbitrators who conduct non-transparent proceedings outside the law. Second, that the rulings of these tribunals constitute an undesirable limit on the power of states to regulate in the public interest. Third, that the process is shrouded in secrecy. Fourth, that states never win. Arbitrators aren't tenured judges with public authority as in domestic judicial systems, but a small clique of corporate lawyers who are appointed on an ad hoc basis and have a vested interest in ruling in favour of business. Fifth, foreign investors benefit from superior protection. And sixth, arbitration is not reliable because arbitrators aren't bound by precedent and they are unaccountable, yet their decisions are imbued with finality. These various strands are often intertwined. The now notorious disputes between Vattenfall and Germany First, over the environmental restrictions placed upon the operation of a coal-fired power station in northern Germany, and subsequently over the shutdown of the German nuclear power industry in the wake of the Fukushima incident, gave rise to harsh criticism of the arbitral process in the German press, of which this is a tamer example. It meets in Washington, behind closed doors. A mysterious panel of 3 judges has the power to condemn a government to pay billions in compensation when a company's investment is at risk. Tellingly, a leader of the German Green Party in Hamburg was quoted at the time as saying that it was a total surprise for us. As far as I knew, there were some treaties to protect German companies in the developing world or in dictatorships, but that a European company can sue Germany, that was totally a surprise to me. Now, ladies and gentlemen, there's more than a hint of doublespeak in that. A spokesman for the environmental lobby, one of the most powerful of the voices raised against protections afforded to investors under the current system, not least when those protections are enforced in favour of Northern Hemisphere investors against Southern Hemisphere states, seems to suggest that these protections are perfectly appropriate in the case of a German investor facing discriminatory treatment or worse at the hands of a third world government. But heaven forfend that any such action should be brought against an EU member state by an EU investor. The plain fact is that none of these complaints withstands proper scrutiny. The vast majority of those who sit as members of investor state tribunals make every effort to fulfill their obligation to serve as independent decision makers, to find the true facts, and to apply the law as they're called upon to do by the case at hand. The few notorious exceptions do not make the rule. Even a cursory look at the statistics debunk the myth that states always use. The latest ICSID statistics, for example, revealed that a tribunal ruled on claims in 68% of cases, while 32% were settled or discontinued. And in the cases in which a tribunal did rule, jurisdiction was declined in 17% of them, all claims were dismissed in 40%, and claims were upheld in whole or in part in 43% of the cases. That does not constitute a record whereby states always lose. The suggestion that proceedings are conducted in secret cannot seriously be maintained in an age when the membership of ICSID or ICSID-administered tribunals is routinely published, as are the awards rendered by those tribunals. ICSID proceedings have even been broadcast live. It's like watching paint dry, but you can do it if you want to. Amicus briefs are regularly entertained, and measures such as the 1 April 2014 UNCITRAL rules on transparency in treaty-based investor-state arbitration are in place. The arbitral community has been astute to respond to calls for transparency. And again, it's interesting to see that it remains to be seen whether states will be as eager to sign up to the Mauritius Convention, thereby acknowledging their consent to the application of the transparency rules in proceedings, whether or not conducted under the UNCITRAL rules and brought under pre-April 2014 investment treaties. To date, there's hardly been a rush. 9 states, including Canada, France, Germany, the UK, and the USA, have signed up since the treaty was opened for signature on 17 March 2015. But since then, nobody's followed. Empirical experience suggests that while investor-state tribunals are not bound by precedent, they are scrupulous to review previous decisions and to consider whether general principles outlined in them are apt to be adopted in the cases of which they're seized. Rights of appeal may be limited. In the ICSID system, they're enshrined in the annulment procedure under the Convention. But decisions are not capricious, and merely because they may not be well received does not make them wrong. I'm inclined to think that David Caron is right to suggest that the investor-state arbitration model has become a proxy for that amorphous concept, globalization, and that because it is readily identifiable, it's an easy target for those who are hostile to some or all of what they believe globalization represents. That is not an environment conducive to sensible and rational debate. And my guess is that the existing investor-state model will be increasingly challenged, and that there must be a real possibility that pressure will increase for the adoption of a 2-tier framework akin to that in the EU-Canada trade agreement, whereby the constitution of the arbitral panel and any appellate tribunal is essentially dictated by the state parties and drawn from a pool of adjudicators for which the criteria for appointment are weighted in favour of those who have held high national judicial office. And to give you the example of the CETA investment chapter, the proposal is that for the investment tribunal and the appellate tribunal, there should be 15 members, 5 to be appointed by the EU, 5 by Canada, and 5 are third country nationals. Each one of these individuals to be appointed for a 5-year term, renewable once. In other words, the right of the investor to appoint a member of the panel has gone completely. And furthermore, there is a commitment to the creation of an international multilateral investment court, whatever that might mean. How much of this will spill over into international commercial arbitration is a question which exercises many in the arbitral community, and rightly so. And again, I'd agree with David Caron's view that I don't see the transparency movement spilling over with anything near the same intensity to commercial arbitration, because although international commercial arbitration certainly supports the conduct of international business, it's not associated with the phenomenon of globalization in the same way. And there's a number of reasons why that should be so, not least because a business-to-business dispute is rarely going to impact a national interest or the interests of taxpayers. What is generally at stake is the interest of the immediate players, their shareholders, and possibly their financial backers. And the fact is that to the extent that transparency is demanded in international arbitration, the institutions are reacting, such that the procedures for the arbitral process are open to scrutiny. Institutions increasingly publish their statistics. A number of long since published sanitized awards. Since January 2016, the ICC has published information on the composition of its tribunals, including the names and nationalities of arbitrators, and whether the appointment is the result of a party nomination, or in the case of a sole or presiding arbitrator, whether it's on the basis of a joint nomination of the parties or direct appointment by the ICC court. Institutions are increasingly making public their decisions on arbitrator challenges, and they encourage tribunals to be proactive in their case management, sometimes, in the view of harassed arbitrators, to the point of being overly prescriptive. But there can be no doubt at all that accountability of institutions and of tribunals is now a principal feature of the arbitral process. But if the pressures are not as acute as those facing investor-state arbitration, one cannot lose sight of the fact that in major arbitral jurisdictions such as the United States, there is a hostility to arbitration evident in articles in the national press, which reflect a process alien to anything that those in this room who are familiar with international commercial arbitration would recognize. Just one example, quotes. In practice, however, arbitration typically takes place in a conference room where parties are seated around a large table. Witnesses may or may not be in the room. Parties may or may not have lawyers. That'll be the day. The arbitrator sits at the head of the table. He or she is not a judge and doesn't wear a judicial robe or other ceremonial garb. Rather, the arbitrator can be any person the parties have designated, although they frequently are lawyers. There's no court reporter or jury. The arbitrator convenes the hearing and usually begins by explaining that it's an informal proceeding not subject to formal rules of evidence or procedure. Rather, he or she explains that the arbitrator's role is to hear any evidence that either side wants to submit and then render a binding decision. Instead of excluding inadmissible evidence based on objections from lawyers, the arbitrator will generally hear all the evidence and then decide how much weight to give it in reaching a decision. Witnesses are sworn in by the arbitrator and the proceeding begins. During the hearing, the party who initiated the proceeding tells his or her story and presents any documents or witnesses that support it. The other side has an opportunity to cross-examine. Then the defending party presents its case, also subject to cross-examination, and the arbitrator may also ask questions of the witnesses. After the close of the hearing, the arbitrator considers the evidence presented and issues an award. Often the award takes the form of a simple statement of who won and the amount of the recovery, if any. Sometimes the arbitrator issues a written decision explaining the outcome, sometimes not. And once the arbitrator has ruled, there is no realistic possibility for appeal. And distrust is fueled further by a subliminal link between all forms of commercial arbitration and the notorious consumer and employee so-called forced arbitration provisions buried away in the small print of the likes of credit card agreements and employment contracts, which compel arbitration and preclude the ability to bring class action suits. In the autumn of 2015, the New York Times ran a series of op-eds under such titles as "Arbitration Everywhere, Stacking the Deck of Justice," and "Arbitrating Disputes, Denying Justice," and which included such memorable observations as that of the Executive Director of Public Justice, who stated that on the basis of a, quote, tangle of bands placed inside clauses added to contracts that no one reads in the first place, corporations are allowed to strip people of their constitutional right to go to court And then he added this: imagine the reaction if you took away people's Second Amendment right to own a gun. So it should be obvious that there's a world of a difference between the form of arbitration which has attracted such criticism and the bulk of the workload of the international institutions which the BVI IAC would seek to emulate. But nothing should be taken for granted, and this centre, along with the others, should be prepared to speak up for the differences. There's pressure too from the newly created international commercial courts, which maintain that they can offer a cheaper and speedier service to users than the commercial arbitral institutions, and which it is inferred, none too subtly on occasion, offer safer hands than do international commercial arbitrators generally, because of course they're judges, or retired judges. The champions of the new ICCs, among them the Lord Chief Justice of England and Wales, suggest that they can deliver a service more cheaply than can the arbitral institutions, and that their ability to render public judgments on matters arising out of standard forms of contract, jurisdictional issues, principles of law, or important forms of interim relief will meet the concern raised in two recent public addresses by the Lord Chief Justice that cases which might enable the courts to develop the law are being lost to arbitration. As the retired Court of Appeal Judge Sir Bernard Ricks, who sits as a judge of the Singapore International Commercial Court as well as a commercial arbitrator, put it, albeit it must be said in a different context and with a different solution in mind, as more and more international commercial cases go to arbitration rather than the courts, we are more and more losing sight of the basic feedstock of our commercial law. As to the first point, control of costs is something over which the institutions have limited powers. They can control their own charges and expenses, and whilst they have to be able to attract good arbitrators, they can exercise some control of the costs of the tribunal. But the real expense in arbitration is party-engendered costs, and it's no different in court proceedings. Only this past week, a case arising out of the public bailout of Royal Bank of Scotland was settled on the eve of trial in the Chancery Division. Much lamented, it must be said, to the hair-coursing fraternity who were keen to see a former chief executive really put through the mill. Mr. Justice Hilliard was, quote, staggered to be told that the costs run up by RBS alone were of the order of £100 million. Any responsible arbitrator will seek to ensure that proceedings are run efficiently and effectively. And it's true that in apportioning costs, the tribunal can ensure that excessive costs are borne by the party that chose to incur them. But all too often one hears the mantra that arbitration has become too expensive, as if it were the fault of the process. That is an issue of which the management of this centre is well aware, and it won't be slow to set the record straight. As to the second argument, speed, the leading institutions have been well aware of the need to encourage procedural efficiency, and tribunals are put under considerable pressure to ensure that it is achieved. They don't have the powers of compulsion available to a sitting judge, but the international commercial courts may be rather wary of using that blunt instrument too readily if they wish to attract business away from the institutions, when that business is largely provided by entities which have come to expect a substantive say in the procedure to be adopted. As to the third point, development of the law, I agree with Gary Bourne that there's something troublesome with the proposition that disputes are there to make law, as opposed to law being there to resolve disputes. International cases go to arbitration because the parties concerned wish to resolve their disputes in private in a neutral forum, which affords them an option to enforce a final decision internationally pursuant to the New York Convention. In my experience, arbitrators will not readily accede to invitations to make law, and they will be scrupulous in their efforts to interpret and apply the law as it's set down by statute or code, or in common law jurisdictions as it has been made by judges. If they get it seriously wrong, in a way which goes beyond the immediate case, then there is scope for appeal, and the courts will have their opportunity to state or restate the law. So to that extent, the new commercial courts may operate in parallel with the international arbitral institutions, but what they offer, I suggest, is something rather different. To sum up, the leading arbitral institutions have come a long way in a relatively short period of time. Whether long-established or relative newcomers, they've generally been responsive to the accelerated pace of change in user expectations and to the demands of an increasingly competitive market for their services. Some of those changes have been dramatic. Who even 10 years ago would have predicted the growth of the third-party funding market to the point that in the course of the past 12 months alone, legislation has been passed in Hong Kong and Singapore to accommodate it, and when asked whether the BVI could surely be far behind, But having said that, on the 23rd of May 2017, the Irish Supreme Court, by a 4-to-1 majority, upheld the prohibition upon third-party funding, although one member of the court was critical of that and said that that was simply the case because of the continuing existence of ancient principles of law, which he suggested should be looked at. Faced with skepticism or worse as to the values of the process and of the institutions and arbitrators who seem to epitomize it, the greatest asset of any institution is a reputation for unimpeachable integrity. The contagion of mistrust that afflicts investor-state arbitration is unlikely to spread to international commercial arbitration for the reasons that I've outlined. But if I might be allowed one minor note in a piece set in an otherwise major key, it would be this. In an offshore financial centre, or as the Daily Mail would doubtless put it in more pejorative terms, a tax haven, it will be essential to ensure that the BVI IAC takes all possible steps to ensure that the confidentiality attendant upon its proceedings is not seen, as David Caron put it, as an opportunity for the facilitation of other than lawful business activity. To sum up, investor-state arbitration finds itself under sustained attack, and it's not easy to predict how far-reaching change might prove to be. International commercial arbitration continues to thrive. The key to its success is its ability to keep pace with user demand, and it has the advantage that it is not hobbled by the attention of public interest groups and the vagaries of political exigency and opportunism. It is not without its critics, though, as some of the commentary to which I've drawn attention makes abundantly clear. There is absolutely no room for complacency, but with a fair wind, which I accept is not necessarily given in the Drake Channel, I'm confident that this centre will grow and thrive as Dr. Joseph Archibald would have wished and expected it to do. Thank you very much.